One that this meeting is being recorded, as you may have noticed from the prompt on your screen. And this recording will be available, will be posted on the website, on the YouTube page of the Access to Justice Board. I want to also announce that the Access to Justice Board has committed to partnering with the Cardoso Law Society to do a CLE tentatively fixed for February of next year, along with the Anti-Defamation League. The CLE will be focused on online hate and harassment. We hope to give you more information in our January meeting. I also want to inform everyone that our letter to Supreme Court, thank you for participating in helping us draft a letter to the Supreme Court to weigh in on the court user fees issue. I want to personally thank everyone for working with Terry, our lead on this issue. We have submitted we have submitted a letter and all the opinions expressed by you all, by everyone, and our community advisory panel and everyone to the Supreme Court. We are waiting a decision from the Supreme Court. So that is as much as we have to share with everyone at this moment. All right. Now, November meeting minutes. This has been circulated ahead of time. It's among the packets that was sent to everyone. Do I have any of the ATJ board members have any questions or motions to adopt the minutes?
Move to approve.
Thank you, Sal. Second, SP, all in favor, aye?
Aye.
Aye.
Aye. Okay, unanimous. Thank you, everyone. Now, last month, we started a conversation. Malu Chavez was presenting to us. Malu, thank you so much for coming back. And we ran out of time. And the executive committee decided to give NOP opportunity to be able to complete that presentation. So Malu is here to help us with that conversation. You can take it away.
Thank you so much, Rasmus. Good morning, everyone. Really nice to be back. And thank you for having me twice in a row. I wanted to just continue from where I left off. I last talked about our DACA portal that we are introducing to the community. I think that was a recent update. But I started talking a little bit about the dedicated docket. Not sure if you guys have heard about it. It's an expedited processing of cases in the Seattle Immigration Court. Right now we have about over 1,000 people, more than 900 people are unrepresented. So we're seeing a lot of families being processed very quickly, and their case is supposed to be adjudicated within 300 days. It's impacting community members who recently arrived to our communities. And so most of the time the people in these cases are not going to have ties to the communities. So there's going to be a lot of chaos in their lives for sure. I wanted to also say that the implementation of the dedicated dockets did not include any funding or added federal programs to ensure families will have access to legal representation in the Seattle Immigration Court. And so then we're seeing that need. Another area that we are seeing is increased numbers of unaccompanied minors coming to Washington State. One program that NERP is recently partnering up with DSHS and the Office of Refugee and Immigrant Assistance is on assisting youth who are placed in the unaccompanied refugee minors program. These are programs provided in Tacoma, Vancouver, Seattle, and Spokane. So this is going to be statewide. and I have 2 more updates quickly. We're very excited about King County's approval of a first in the nation program to help immigrants apply for status by helping pay their fees. I think it includes a $5 million fund to provide these forms of assistance for people who are filing forms or presenting their case before immigration court. And the last update I have is that on January 11, coming up, our legal director, Matt Adams, will present arguments before the US Supreme Court in a case called Garland v. Aleman Gonzalez. And he will be defending an important victory we've already achieved for our clients. These are a legal issue that's very complex, but essentially we won a favorable ruling before the Federal District Court in Western District of Washington, which required immigration authorities to provide our clients with a bond hearing before an immigration judge. So people who were in detention at Tacoma for more than 6 months were being offered this bond hearing. And so this is going to be a big case. There's also frustrating aspects to it. It's a combined case with some of our partners out of Northern District of California. So we'll see how that goes. But I just wanted to give you a sense of how busy it is. I guess one last update is our new development of trying to provide services to Afghan community members who are now relocating to Washington State. We expect more than 2,000 Afghan community members, hoping to provide as much assistance as we can. So there's a lot of need happening right now in the immigrant rights arena. Thank you, everyone.
Thank you so much. Any question or request for clarification? For NOP? Oh, SP, go ahead.
Yeah, hi, Malu. Thank you for that report. Do you have any specific or maybe even general ideas of how the ATJ Board and the Alliance could be supportive of the immense need, right? And in supporting the different projects and programs that you have going, and looking into 2022, we know it's going to be very challenging in immigration and in some other areas of law. Maybe some kind of guide from you on that?
Thank you. I think being informed, I think showing up, and I know that legislative session is coming up. Hopefully we either maintain funding or increase funding. I think that's going to be very important. Our pro bono work is very important. So to the extent that we can continue sharing that information and also for community members, sharing correct information would be important. Thank you so much for asking that question, SP.
Anyone else? And I'm hoping that beginning from next month, we would also be able to have some information from legislative advocacy. Hopefully we would ride the coattails of CLS, thanks to Merv and to Antonio, to be able to get information about what is going on at Olympia. All right. Any other question or comment for Malu? Okay. We now go to a discussion on the Rule Committee proposals, and Judge David Keenan will take it off from here. Judge Keenan.
Thank you, Francis. So this is with respect to a proposed amendment to a rule, which is Civil Rule 39, trial by jury or by court, and then a new general rule, jury selection by video conference. These have been both proposed. I think the proponents are King County Superior Court judges. I think probably the lead is Judge O'Donnell. I'm not one of the proponents. I chair the ATJ Board's Rules Committee. And if you look in your packet, I think it's at pages 7 through 10. I've drafted a letter. It's about 2,000 words, so there's quite a bit in there, and it's not my intent today to go through that letter word for word, but rather to just highlight a few things and then inviting any discussion. And then the ask will be for a motion that we approve the board sending this letter in for comments to the Supreme Court as they consider these rules. Comments are due by December 29th. So the action, if it's going to happen, needs to be at this meeting. So just a few things to highlight. If you were to just read any part of the draft letter, paragraph 1 has a roadmap which sets out all of the comments that I'm proposing the board make concerning the rule. So one comment on a high level is that with respect to remote jury selection, that GR 41, the new rule that would allow juries to be selected by video conference, would allow, not require, that it not further exacerbate underrepresentation of jurors of color in the jury selection process. I've picked 8 juries over Zoom, and I've had 28 trials over Zoom since the pandemic started. I am concerned that this not exacerbate the already problematic underrepresentation of jurors in Washington. Also, one concern that I would suggest the board raise is that the ability to conduct remote proceedings is going to vary significantly from jurisdiction to jurisdiction. It's one thing if you're in King County, where we started doing remote hearings and remote jury selection right away. I worked on a BJA group earlier this year on a related issue, and I remember talking with Judge Estudillo, who's now federal Judge Estudillo, about his inability, because he didn't have the resources that we had in King County, to do all of the remote things that we were doing, but in his county, which was Grant County. So that's one concern that I would suggest the board raise. Another concern I would suggest the board raise is that jurors and parties not be disenfranchised on account of lack of access to technology. Again, I think that technology is going to, access is going to vary considerably. And what I don't see in these proposed rules is much guidance, really any guidance on what courts, I mean, actually, I shouldn't say that. There is some guidance on what courts would do if a party does not have the ability to access proceedings. I would suggest that the board just make sure on that technology access front that we comment about parties having meaningful opportunities to pursue their case. So in other words, so as I say in the draft letter, it might not be enough for the court to just ensure that for example, an unrepresented litigant in a rural community without much internet access, might not be enough to just say, well, do you have a computer and do you have access to the internet? I think it's fair to ask, is that meaningful access to justice when we're talking about remotely accessing a trial or jury selection? Also, and I think this is really important to highlight, the board, I think, should comment that care needs to be taken to protect the rights of members of the community who live with disabilities in accessing remote jury selection and accessing remote trials. And I presented earlier this year at Spring Judicial Conference with Justice Whitener and Judge Wedby and others on working with jurors living with disabilities. And there's a lot of technology and other accommodations that I think could and should be made, but these rules don't really don't call those out, and it might not be enough to just say, well, GR 33, which deals with disabilities, already exists. I think there might need to be some specific language here in the proposed rules. And then also, the board, I think, should comment that trials involving interpreters not be treated differently than parties to trials without interpreters. And the reason I recommend that is that there's language in the proposed amendments to CR 39 that say, quote, whether the use of remote interpreting services will detract from the presentation of evidence, end quote. And I just don't know what that means when they say detract. courts work with interpreters all of the time, and interpreters do not detract from the proceedings. What they do is help provide meaningful access to justice. And so I think there's some clarification needs to be made there. Also, although the Access to Justice Board works on civil legal aid, not criminal legal aid, I think it is important to raise the issue of when someone does have an attorney, that during a remote proceeding, if the attorney and the client are in different locations, that they have a meaningful opportunity to communicate with one another. And this came up in a recent Court of Appeals case, in a criminal case, where the court held that because the defendant was someplace else, that wasn't enough. It was a constitutional violation because the defendant did not have the opportunity to consult meaningfully with their attorney, given that their proceedings were remote and they were in different locations. And then finally, there are provisions in the rules that talk about judges not allowing virtual backgrounds without permission. And I understand why that is. I mean, again, I've had hundreds of hours in Zoom trials now since the start of the pandemic. And the concern is there somebody else in the room, somebody giving you the answers, is somebody telling you how to testify? So I understand why that rule exists, but, and particularly because we are the Access to Justice Board and everybody here, I think, are members of alliance providers, we don't want to humiliate a low-income client, for example, that for whatever reason might want to obscure their background. Not everybody has access to a perfect home office or someplace to testify from or participate in jury selection, for example. And then kind of the last thing the letter says is I would recommend that the board recommend to the Supreme Court that whatever the court does, whether they adopt the rules or whether they decide to do more work, that there be some sort of a working group to consider further developing these rules, and that the ATJ board participate in that. And so I'll stop there. And I see some questions. So the person who just says she, her, Aya, who is that? Sorry, I know what Aya means. But
Esperanza.
Okay, but Esperanza doesn't actually have her name in the title.
Right.
So Esperanza, did you have a question or a comment?
No, I didn't. Was my hand was still up. Sorry, it's
All right, but Sal has his hand up. Sal.
Yeah, well, you made a request. I was just going to follow along your lead. You asked for a motion, so I'll move that the board send the letter.
Because this is coming from a committee, for a committee report to the board, I think we can proceed to full vote based on the request from the committee, unless it's not from the committee.
Yeah, I didn't understand it was from the committee,
Yeah.
but you are correct, Francis. If it's from a committee, it doesn't need a second. But if it's just Dave, then it does.
Well, so it is sort of, it's a bit of a hybrid, and I think it's easier to go Sal's route, which is a motion and a second. And the reason I say that is the committee just said, we think this looks okay. At the last meeting, I discussed that, and then Sal had questions, and I think a lot of good questions. And so I personally, just as the chair of the committee, did a much deeper dive into all of the rules and came up with this. So I think Sal has moved, and so perhaps there's a second.
Terry, second.
May I speak to the motion just briefly?
Yes.
First of all, Francis, thank you. I mean, I love how you got the rules, and I love that. So I just want to commend you, my friend. You're spot on, and I love it. Second, Dave, I just want to say great job. I mean, I had my concerns. Man, you knocked it out of the park with this letter. You addressed all of them. I think it's well written, well thought out, and I think it's exactly what the Access to Justice Board should be doing, advising the court on these matters. So that's the reason I made the motion in favor of sending this letter.
Any other discussion? All in favor, aye? Or just use your thumbs up? Okay, let me make sure I do all the counting. Okay, okay, thank you, everyone. Miriam, how do you vote? Okay, so Bonnie, for the record, we can mark Miriam absent on that vote. Lindy gave a thumbs up. So just mark me absent on that vote. All right. Judge Keenan, anymore? All right. We now go to Michael. I think Michael is there. Michael, over to you on the demographic data collection for the new eviction right to counsel.
Hey, thank you, Francis. Good morning, everyone. I think I know most of you, but I see a couple new faces perhaps. So my name is Michael Terasaki. I'm the Washington State Pro Bono Counsel Manager, and I coordinate and support the volunteer lawyer programs across the state. I'm here this morning to talk about something that is kind of transcends, I think, just the volunteer lawyer program kind of scope. And Eva Westcott is also here from NJP. And I'm going to pass it over to her in just a moment to kind of explain a little bit more what we've been working on. I think it's included in the materials, but I'm going to drop in the chat here both a memo that we've drafted and kind of a feedback form that we're using to try and capture as much feedback as possible. And this is a project to try and make not just the data that we get through Legal Server as far as client demographics better, but also to kind of improve the way that we ask those questions and kind of improve the client side experience of collecting that demographic data. And we did have just for background, we did have one listening session already yesterday. We're trying to share this as far and wide as possible. We got some really good feedback. We had more than 20 people there, and we do have a second listening session for Monday at 9 a.m. But like I said, we also have a forum. Anyone can submit feedback. And like I said, I'm going to pass it to Eva in just a second. But I think our big ask for the ATJ board today is to kind of share this as far and wide as possible, particularly with any community partners or anyone or any organization that interacts with legal aid clients, so that we can really get that feedback back. I think we're pretty good at getting people and feedback from people within the Alliance. I can just knock on doors and get their feedback, but it's the others, the people that we're missing that aren't normally consulted, that I really appreciate getting some feedback from. So with that, Eva, maybe you can explain a little bit about what the memo is and how we got there.
Hi, everybody. My name is Eva Westcott. I am at the Northwest Justice Project. I'm a senior managing attorney for client access. I work really closely with our CLEAR team, our screening unit, the Washington Law Help team, and our pro bono and private attorney involvement groups. And so I've been working with Michael and others in the pro bono community as we are preparing to implement all the different system changes that we need to move forward with right to counsel. And we're in this position where we have actually some additional resources to really look at how Legal Server is set up. And we acknowledge that Legal Server is not the same case management system that all of the providers across the state use, but many of us do. And one of our goals in trying to, as we're making some of these updates and we have some resources to look at this, was to make changes that that would allow us to have additional drop-down options when we're asking about demographic information, to be able to gather information about how people actually self-identify, and then also to gather more detailed information just for us to be able to better understand who we're serving, what is happening with clients when we're serving them, to be able to better address, just have a better understanding of who's getting to us and who's not getting to us. I will just be the first to say that this process has been somewhat fast and furious. This year has been a wild ride as we implement right to counsel. Ultimately, where we get the best information is from the folks that we work with, the folks that are seeking legal services, have the most to say about how we ask these questions and what information we gather. We have not had the bandwidth to do focus groups, and my hope is that with some of the changes that we're proposing here, we can do some regular updates to our demographic information, so we do know that we're gathering the information we need to assess how we're doing as legal service providers. In the memo, we talk about some of the changes that we're looking to implement, including greatly expanding gender options, providing framing and how we, why are we asking these questions, and providing some assurances to folks who are seeking legal services about the whether or not their private information is protected. Some of the changes that we're looking at making really change kind of the structure of how we ask the questions, and that is in particular with race and ethnicity. We're combining those questions and allowing people to select more options. We're looking to expand the lists, and then this information will kind of map back to, for Northwest Justice Project, we have to report to LSC, so it'll map back to what reporting is required to LSC, but then we will have access to more detailed information. With that said, we're not experts. The team that I worked with, which was with Michael and Elizabeth Fitzgerald and the Clark County Volunteer Lawyers Program, and then Catherine Brown, the screening unit managing attorney at NJP, as well as Kat Williams, who's NJP's legal server and data specialist. We are working to try to make updates to this, but we're not experts in each of these individual areas, and we're really seeking input on what's included in these lists. We've got some fantastic feedback yesterday, and there's already changes that we're working on implementing, including some of the people first language, adding some additional options. So we're really wanting to engage with folks so that we can make updates, roll them out, and then assess them periodically over time, so to make sure that we're gathering the information that will help us better serve our clients. So, Michael, please jump in if I left anything off there.
I think that's it. I think we threw kind of a lot of information at everyone just now. Like I said, we're really looking for any connections to people who can give us more feedback at this point.
I have a suggestion. We have a spreadsheet that we put together when we were, the conference planning committee had a huge list that had input from our community advisory panel and everyone in terms of outreach that we did for the conference, which makes this ATJ conference the largest conference with people that are recipients of civil legal aid services. So I don't know if Bonnie and still have that spreadsheet and can share with you guys. It has emails and every other information that you can use. And of course, you'll still have access to the community advisory panel that help us put that together. All right, Michelle?
I was just going to say, I think that spreadsheet has been shared with NJP, although I don't know if it's been shared on this particular project. So I'll make sure that they get connected to it.
Perfect. Anyone else? Thank you, Eva. It's good to see you again. And thank you, Michael. We appreciate it. All right. Now we go to the next issue on the agenda, which is a discussion regarding WISBA's structure. And I'm happy to say we have in our midst today the Executive Director of WISBA, our host. The Access to Justice Board host is WISBA. Tara, you're welcome, and you can take it away.
Thank you. Thanks so much for having me. Nice to see all your faces on this Friday morning. I'm going to do a quick PowerPoint here. So I'm going to talk a little bit about some of the issues impacting or making us think a little bit more about the structure of the Bar Association. One thing I want to say is this is going to be pretty high level. If you really are interested in like geeking out on the holdings and the facts, that's not me. But I'd be happy to come back with some folks from our Office of General Counsel or set up some time one-on-one so you could really dive in. I really today just wanted to sort of present a high-level overview of what the issue is and invite you to participate as we sort of navigate through it. So you know, so the long and the short of it is there are questions about whether an integrated bar association structure is constitutional, because we are requiring people to be a part of the organization. We are requiring them to pay a membership fee. And so that potentially impacts their First Amendment rights in terms of both association and speech. And I'm gonna talk a lot about integrated bars, and I'm sure all of you know this, but there are a variety of different models of bar association. In some states, particularly on the East Coast, the regulation of the practice of law, so discipline, admissions, is largely handled by the Supreme Court. And if they have a bar association, it's voluntary. The more common model on this side of the country is to have an integrated bar association, which means that we not only engage in the regulatory activity as delegated by the Supreme Court, but we also engage in activities that might be considered more professional association type activities. So these two cases have really, Lathrop v. Donahue from 1961 and Keller v. State Bar of California from 1990. These two cases have really been the lay of the land for quite a while for us. Lathrop established that it is constitutional to require membership in a state bar. And they said that was because we have legitimate interests in raising the quality of professional services. A little while later in the 90s, this case called Keller arose out of California, and California State Bar was engaged in a lot of legislative activity, a lot of advocacy, I think, around a lot of issues. I think gun control might have been one of the big issues that got people excited, and it led to some lawsuits questioning whether the Bar Association was impeding its members' free speech. And State Bar of California reiterated that compelled association in an integrated bar is constitutional. And it set forth the standard that we continue to look at, which is that it's constitutional because of the interest in regulating the legal profession and improving the quality of legal services. And those two criteria sort of became what we consider germane. So if we're engaging in an activity that fits into one of those categories, regulating the legal profession or improving the quality of legal services, we consider that to be germane to the purpose of a state bar association under Keller. However, Keller also said that if you're doing anything outside of that, that's non-germane, you can't require people to pay for it. And so that's why in Washington, we have a Keller deduction, and many other integrated bar associations have something similar. Okay, I also wanted to just quickly turn your attention to General Rule 12.2. So this is a Washington state rule, and it's sort of what we consider the state bars, or the Supreme Court of Washington telling us what we can do, what we can't do. And relevant to this discussion is that near the end of General Rule 12.2, it says that the Washington State Bar Association will not take positions on political or social issues which do not relate to or affect the practice of law or the administration of justice. I italicized those last words because I think when I talk to folks, usually there's a lot of interest on the political and social issues question of it, but I actually find a lot of our discussion usually is around whether or not the particular thing we want to do meets the second part of this. Does it affect the practice of law or the administration of justice? And a lot of times this comes up when we want to do some kind of legislative advocacy. And the way that historically we've interpreted political is not something that's controversial or sensitive. It's just something that is in the political arena. So any kind of legislative advocacy is usually considered to be political. And it doesn't mean we can't do it, but then the question is, does it fall into one of these buckets? So this is sort of the decision tree that we have been operating under. The first question that we always ask when there's an activity coming forward, and again, usually this is in the concept of engaging in some kind of speech. So the first question is it prohibited under the court's rule, under GR 12.2? If the answer is yes, then we just don't do it. That's the end of the conversation. Now, I think the the Access to Justice Board and other Supreme Court boards, it's an interesting question whether GR 12.2 applies. I think many would say it does not. It was a question that came up in the structure work group, which I will get to in a minute. I'm not going to talk about a lot today, but I just sort of wanted to flag that. So if we consider that it is appropriate to engage in this activity under GR 12.2, the next question is, can we require people to pay for it? Or can we use compulsory license fees under the Keller case? And so now we apply a sort of similarly worded but slightly different standard, which is this activity germane to our interests in regulating the legal profession and improving the quality of legal services? If the answer is no, it doesn't mean we can't do it. It just means that we're going to include it in the Keller deduction. So these standards are related, but they're not exactly the same. And there's a relatively small universe of things that we are allowed to do under the court's rule, but that we can't require people to pay for under Keller. And a lot of it is our legislative activity. One thing I want to point out here is that under the WSBA bylaws, when we are determining what activities to include in the Keller deduction, we are asked to be very conservative. So we put anything in there that we think is questionable, we will tend to include in the Keller deduction. Okay, so that was the lay of the land. And then in 2018, there was a case called Janus. And Janus held that the First Amendment forbids the government from requiring their employees to pay union fees. So this was a union case. It didn't have anything to do with bar associations. However, it overturned a case called Abood, which had really formed the basis for Keller. And so we were left with this question: if Abood is no longer good law, what does that mean about Keller? Is this still good law? And there were a number of lawsuits that were being brought across the country based on Janus's holding. So in response to this, the Supreme Court created a structure work group. One of your ATJ board members, Esperanza Borboa, served on that work group. They met, over many, many months, and they issued a final report. These are the recommendations from the final report. And as you can see, there's bullet point number 3 is the one I mentioned, was to consider amending the court rules to make clear whether or not GR 12.2 applies to court-appointed boards. That has not happened, so nothing has changed there. But the primary recommendation was to retain our structure. I think the finding of the majority of the work group was, it's not clear at all that anything's changed. We're not convinced that anything is going to change, and we think that this structure is the one that we should keep. There was also a minority report. And this was what the Washington Supreme Court wrote back to the Bar Association. And again, I'm mostly just going to focus on the first one, which was that for now, and they did say for now, we will retain our integrated bar structure. So that happened at the end of 2019. So why are we still talking about this? Well, the litigation has continued. And so going back to sort of that first slide, there's the association issue and there's the speech issue. And Keller was really focused on speech. Like, can we make people pay for things, basically? But the litigation has continued. And in particular, in the Fifth Circuit, there have been some holdings that really sort of call into question where things are going. And they relate to the association claim. And in the Fifth Circuit, they told the Texas State Bar that if you engage in any activities that are not germane, you are violating the First Amendment rights of association of your members. So in other words, you just can't do it at all, and we're not sure what the remedy is. Is the remedy that they don't have to pay the license fee? Is the remedy that they don't have to join the organization? We're not sure. Now, this is in the Fifth Circuit, so it's not binding on us. In the Ninth Circuit, we have a case pending against Oregon. And the Ninth Circuit did find that there's a viable freedom of association claim, and they remanded that back to the lower court. And so that's sort of ongoing. So this sort of calls, so potentially we are all just sort of wondering whether this is still going to be our decision-making framework. One thing I really want to emphasize is, you know, change our rules. You know, there haven't been any court decisions that are binding on us, but we do feel like the risk landscape has changed. You know, there's a greater likelihood that we could be the next bar association to be sued. And I think the question before us is, you know, what kind of position do we want to take? Do we continue to believe that this is the best structure that benefits the profession and the public? And do we want to defend it? And if so, how do we put ourselves in the best position to defend it? Or do we want to make some tweaks to the structure to either, you know, because we think those are the right things to do, or because we think that that will lessen our risk? And so the court has asked, oh, I thought I had another slide. The court has asked there it is. The court's asked the Bar Association, in particular the Board of Governors, to make some recommendations to the court. And there's going to be a special meeting on December 14th. And this is really intended to be to talk about process. What kind of process is the Board of Governors going to undergo in order to evaluate the options and make a recommendation to the court? I know that when the Chief Justice spoke to the president, he emphasized, you know, that the court would have an interest in this being a very open and inclusive process. And so I do think a lot of this is relevant to the ATJ board. And I hope that, I mean, obviously you have Francis Adewale, who serves on the Board of Governors as well as being your chair. So you already have sort of a clear liaison to these activities. But I would certainly invite and encourage you to follow along, participate, and, you know, give input to the board about not only what your opinion is about, you know, where the legal issues are going to go, but what do you think is good and valuable about the structure, or what do you think could stand to change? Because I hope and I expect that part of this process for the Board of Governors will be to start by, you know, sort of thinking about what is the best structure for the state of Washington. So I'll pause there, see if there's any questions.
Thank you, Director Nevich. Any question, request for clarification? Yes, Judge Cobbett. Yes, Judge Cobbett, before we have two members on that committee, Judge Cobbett as well as SP. Go ahead, Judge Cobbett.
Sorry.
I don't think the Ninth Circuit has changed the landscape so much that we should be so bashful about continuing to do what is good. I fear that what we're doing is we have a group of people that want to rehash the minority report. I would suggest all of you read the minority and the majority report. It was well thought out. We looked at the constitutional concerns that were raised, what we were doing in this court, and some bright minds, including law professors and other minds like mine, came to the conclusion that the fear that we need to backpedal from doing our good work is overplayed. Thank you.
Thank you, Judge Cobbett. Any other question or comments? SP?
Yeah, I think that this issue will keep coming up, and it is, right now it's a minority report, but I think it's going to keep coming up. And I've seen this in other areas, not just in the legal world, where when there's an opening or perceived opening by those that may oppose what others are doing, that they will keep building the momentum and making the wedge bigger and bigger and bigger until they're successful. And I think that this is connected to the work that the legal community has taken on over the last several decades around access to justice. There's a change, it changed the landscape of the legal world. and, you know, community voices, community lawyering, all these things are threatening to a structure that was not set up and to do that in the minds of a lot of folks. So I think it's really important to, I agree with Judge Corbett, read the minority report, the majority report. I kept thinking after doing that, being in that that group, that, okay, phew, that's done. I won't have to deal with it. And I knew that I would, you know, that, I mean, that we would, that people would, if you care about justice, that at some point you'll be going back and hearing about the continued issues on this. But it definitely is going to keep going. They are not going to give up, and which means we can't, and we should be as informed as possible on this. And it's it was very mind-numbing for me as a non-attorney to read through those. And I think I pulled on some people that are in this group to help me understand some of the ideas and concepts that were in some of those cases, because but I learned more than I thought I ever would. So thank you for that report, Tara. That was great.
Thank you, Diana.
Yeah, I was just going to add to that, and you know, it's really helpful that Tara is giving us the background, and that our own bar is monitoring this and trying to figure out what we want to do. And I also think it would be good for the ATJ board to consider reaching out to your peer ATJ commission peers across the country, especially those who are in states who have been more directly impacted, like in Texas, to just learn, you know, learn from them what, you know, everybody's in a different place, but we do have the benefit of being part of a network of ATJ commissions across the country. And we just had a conference last year for the chairs and the staff of the commissions. And this topic was one of the topics for that agenda. And so Bonnie and I could follow up with you all about identifying specific folks that you might want to talk to if you're interested.
Thank you, Diana. I actually brought that issue up in the ATJ Commission's conference last week and in my work group, and we raised the issue, and there doesn't seem to be a lot of concerns by other, maybe because of their structure, maybe because of the way they were set up. But a couple of us across the state, especially West and Midwest, are really concerned about this issue, and we agreed to explore it further. And we were going to ask Shubi to put it on the agenda of the ATJ Commission's meetings that we do monthly. ATJ chairs and board chairs and commissions chairs meetings. So we would definitely report back to the ATJ board on public sessions on that. So any other question for Director Nevitt on this issue? Okay, Director Nevitt, I have another question unrelated to this, but for the Board of Governors. The Board of Governors set up the STARS committee, the small town and rural, I can't remember the acronym. When the Board of Governors was setting it up, usually, because this is a policy and a fundamental issue that's really directly impacts representation both on the criminal and the civil side across our state, especially in small towns and rural communities in our state. The Board of Governors did not request for liaison from the ATJ board when they were setting it up. What process do we need to take to ensure that ATJ board perspective are brought to bear on during the deliberation of STARS committee?
Thank you. Yes, I think they've identified a number of gaps in representation on the STAR committee. I know I also spent some time talking with Office of Public Defense, and you know, they have a interest also in this topic because obviously, you know, the rural gap is affecting both the civil and the criminal side, and government attorneys as well as private practitioners. I think, I mean, ultimately, the way this would normally work is the committee itself would propose a revision to its charter, which the board would approve, typically on consent for something like this. So I'd be happy to take something to the committee myself, but I think that's probably the easiest process.
All right. Thank you. All right. Any other question for Director Nevitz? You know, we get to have her once in a while, so let's make maximum use of opportunity to have the director here in our meeting today. Thank you so much. We appreciate you, Director Nevitz. I believe EJC, Will is still on leave. I don't know if Kirsten is here to represent Will. Kirsten, are you there?
I am here and I am just listening, but no report. Thanks for asking though, Francis.
Thank you. I appreciate that. Cesar said he would not be in this meeting, but will send an NJP rep to provide reports. Any NJP rep that Cesar has briefed to provide reports?
Well, good morning, Francis. I'm Abby Duckies. I know some of you, and I'm excited to join my first ATJ board meeting as an NJP representative. I'm the new director of advocacy. I say new, but it'll be 3 months on Monday, but it feels a lot longer, I'm just gonna say. In terms of federal funding, which is the brief update we've got today, many of you know I worked for the federal government before coming here, and I thought I was done worrying about continuing resolutions, but it turns out no, we still don't have a budget, and so we are flat until February 18th when they are supposed to figure something else out in Congress, and with some anticipated cuts due to census data, we are flat until then. So we're holding tight, and any optimistic projections we had from earlier in the year are all up in the air, which is making everyone's lives really exciting in this time. So no news isn't necessarily good news, but that's where we are right now. Thank you. I appreciate you. We've come a long way. Yes, we have, Francis. Nice to see you. Nice to see you. I don't see Jim. Bonnie, did you see Jim? Or okay, I don't see Jim, and Caitlin is not here also, and we don't have Natalia. So we will push all those reports and all those reports to next month. Now we go to any update or announcements. Any update or announcements? I just want to use this opportunity to say a big thank you to Merv Herman. She's worked with me on DISCO as co-chair. This month will be our last month co-chairing DISCO with me. We are having an election next week. I just want to say a big thank you to Merv. I'm so grateful to have you as a friend and as a co-chair. Thank you. Right, thank you, sir. We really appreciate your work, and I mean, it's monumental. Merv has challenged me, has challenged us as a community to look at what we do beyond the face value, beyond virtue signaling. One of the most profound impact that Merv has made on me, working with her on DISCO, is to be able to re-examine and reflect on what we do, not just the, on its face value, to examine what we do and why we do what we do. And I'm so grateful to be able to work with you, and I wish you all the best. All right, sir.
Thanks, Francis. 3 things. 1, yes, thank you, Murph. You are great. So that's one of the 3 things. 2, just remind everybody about the Gold Mark lunch. It's on February 11th, right after the ATJ board meeting. Make sure you get that on your calendars now. It's always a great event. And of course, we should have 100% showing on that. And 3, just finally, we're coming to the end of the year. For those of you who can think about giving one more gift to either the Campaign for Equal Justice or the Endowment for Equal Justice. So important for supporting all of those who provide those services to those who otherwise can't afford an attorney. Thanks, Francis.
Thank you, sir. I have to read out the committee meeting this month because all our committees meetings have been adjusted to accommodate December holidays. Disco meeting, which is usually on the 4th Monday of every month between 12 to 1:30 p.m. Next meeting is going to be December 28th. Thank you, Diana. The technology committee meeting is 3rd Tuesday of every other month. This month meeting will be on December 14th. And rules committee, Judge Keenan committee, 3rd Tuesday every other month. At the next meeting is going to be on January 18th. Any other announcements? Otherwise, we have 30 minutes off this month to enjoy the holidays. We're trying to make our agenda as light as possible so that we can focus on important issues. So thank you so much for coming. We appreciate you all. See you next month.
Happy holidays.
Thank you,
everyone.
Francis.
Stay
Happy
safe.
holidays. Bye.